Before we get started, I'd also offer our legal disclaimer, just saying all this information is presented in good faith and should not be used or taken as legal or tax advice. And our featured speaker today is Michael Harrington of FordHarrison Law, and he's an attorney at law. So I will turn over to Mike so he can introduce himself as well as take it away.
Thank you, Kyle. So good afternoon, everyone. Let me just take care of that. Okay. So good afternoon, everyone. As Kyle mentioned, my name is Mike Harrington. I have been practicing employment law for a little over 25 years now. And this topic is a little near and dear to my heart because my first job when I was 14 years old was working on a dairy farm in Somers, Connecticut, milking cows. And I did that when I was 14 and 15. And coming home covered with manure then led me to look for a slightly different job when I turned 16, although I look back on those years and they were absolutely fabulous, helping not only milk the cows, but deliver some calves and do some other things on the farm. So I think it's great if young people get those opportunities to work in agriculture and understand where our food comes from. So it's a real pleasure to have been invited to spend some time with you today to review some of the rules surrounding employing minors. One of the things I wanted to mention is
Mike.
Yes.
Can you go ahead and share your screen, please?
Oh, I'm sorry. And how do?
You should have a little pop-up that says share my screen.
Oh, it did, and I thought I checked yes, and it went away.
Okay.
Is there a way to?
Yes, I can. Yep, I'm going to go ahead real quick. Let me just switch it back to myself, and then I'm going to make you presenter again. So you should have like a little pop-up.
Yep, it says share screen, so then what to hit?
Just click yes, or show my screen.
Okay, did that work?
Yep, there you go.
Okay, terrific. Okay, now we're in business.
Yes.
So one of the things I was mentioning to Kyle before we started was each of these states have their general rules about employing minors, and then very frequently we'll have caveats that these rules may or may not apply in certain circumstances, and very often agriculture is mentioned. Where the rule has been clear, I've tried to set that forward. There were some areas that were less than clear, so I included what I consider the more conservative advice. But what I would suggest is if you are employing minors, just to either double check with your local Department of Labor about what roles you might have minors working in and the time that you have them working if they go to the outer limits. And we're going to see a lot of commonalities between the 8 states that we're going to look at. But let me get started here by saying that all of the issues, all of the states, federal and states, really involve 3 main topics when it comes to employing minors. Is do you need certain working papers that they get typically from their school? What time of day and what days can you have them working, and how often can they work, depending on their age and whether school is in session or not. There are restrictions in most cases. And then what can you have them do? There are federal restrictions on certain activities, and then some states go beyond the federal law and prohibit other activities. What you really want to be thinking about, if you want just a general takeaway rule, is you want to be thinking about, one, am I interfering with the child's education in any way, meaning having them work when they should be in school, having them work too late a night before school begins, and do I have them working with any sort of equipment that could be dangerous to them? And you'll see how those concerns play out in each of the items that we discuss. So let's start with federal law. So federal law, in all cases of employment, sets the floor. So no state can allow what federal law prohibits. So just like federal minimum wage sets the floor, but a lot of states have higher minimum wages. So states can always pass more protective statutes. So it's the right place to start is to look at what federal law requires. So federal law outlines what minors can do. So 18 years or older, any job in agriculture. 14 to 15 can work in agriculture, but only non-hazardous jobs. And we'll talk about what that means. And then 12 to 13 can only work if their parent has given written permission or the parent is working on the same farm as their child and in a non-hazardous job. So as a general rule, 14 is going to be probably the age at which you don't want to hire anyone younger. We're going to see there are exceptions if this is obviously a family farm. I think every state does include exemptions for family-owned businesses. But as a general rule, 14 is probably your safe age threshold. But in certain circumstances, children as young as 12 could work on a farm. Okay. When it comes to federal limits of time, the federal legislation does limit what can be done, and again focuses on whether school is in session or out of session. Again, for the federal law, if you're 16 or older, generally no restrictions on working in agriculture. But if you're younger than that, there's when school is in session, only 3 hours a day could be spent working, with a total of 18 in a week. When school is not in session, and that means it's closed for the entire calendar week, 8 hours a day up to 40 hours a week. Okay. The big federal law plays a very significant role in identifying what types of jobs are considered presumptively hazardous, such that a minor is not allowed to work in them. And for federal law, that's defined as anyone under 16 years of age. But there are exceptions. If this is a family-run farm and the child is, parents own the farm, or if it's being done in connection with a vocational education training program. There are several what are considered hazardous occupations identified. I've set them all out, and I'm not going to walk through each of them specifically, but depending on the type of farm that you are involved with, you'll want to look through the list to see if any of these in particular apply to you. They get very specific in terms of certain machinery that might be run. It wasn't a farm case that I had a couple years ago, but it was a coffee shop, and a 16-year-old was allowed to work there, but what they weren't allowed to do was work the elevator. And the reason why, it was a commercial elevator. And the Department of Labor came in, and I can tell you they are very concerned when there's ever any machinery that could cause harm to a minor. And in that particular case, because it was an industrial elevator, and the 16-year-old was bringing the trash down with this elevator that did not have full safety measures, the department ruled that that was a hazardous condition, and the minor could not perform that task anymore. In this particular case, this federal order outlines very specifically the different types of equipment that could be deemed hazardous. If you have a piece of equipment that's not on this list, but you think can still cause injury, it might be best not to have your minor employees operating that equipment. But give you some flavor of the types of equipment, certain types of balers, tractors, forklifts, different combines, chainsaws, um, different type of ladders going up on a certain height, driving automobiles or trucks, all are impermissible for employees less than 16 years old. Go through those. Now, when it comes to minimum, what rate of pay, and this is another area where some states allow for some deviation, and federal law does as well. It's important to remember if you're going to pay less than minimum wage, you need to double check about whether that is permitted by your state law. Federal law does allow less than minimum wage for individuals less than 20, actually, but only for the first 90 days of their employment. So if you decide to deviate from minimum wage, be sure to calendar that time period and to double check whether your state allows that or not. Okay, and it comes to proof of age, because there are certain rules that are allowed for people under 20, most of them for under 16, but we just mentioned the wage hour for under 20. Federal law requires that you keep a record of date of birth for all minors. This is probably something that you would satisfy through one of your other obligations, such as an I-9 form, where a passport or a driver's license will identify the person's age. If not, need to identify a document, maybe a birth certificate, which is also can be used for an I-9 to keep for record of the age of the individual you're employing. That's important not only under federal law, but it's going to be important under these state laws, depending on the age of the employee. You may or may not be able to use them in certain ways. So you want to be very clear about what is the age of your employees so you know how you can properly utilize them as part of your workforce. Okay, so we're going to begin with New York, and then New Jersey, and then we'll work our way through New England. And what you'll see, interestingly, is New York, New Jersey have some of the more developed restrictions. Some of the New England states have very few, which means then only the federal law might apply in some of those instances. But beginning with New York, and you'll see very common themes as we work through the different states. So beginning with New York, there are certain times that individuals can work depending on whether school is in session. For New York, individuals under 14 may not be employed. If schools, regardless of school, but they can be used for hand harvest, for berries, fruits, and vegetables. If they're over 14, they may work after school hours during vacations within agriculture. They cannot work in any factory work, but they can work in agriculture. 16 and 17-year-olds not attending school can certainly work full-time. So if you do have a 16 or 17-year-old who's interested in working, you want to be clear about whether that individual is still in school or not. Okay, in terms of employment certificates, most maybe all of the states we are going to be looking at do have general certificates or permit requirements with a few exceptions. So in New York has a specific farm work permit for minors who are 14 or 15-year-olds. And also, if you were to have someone younger than 14 doing one of the limited hand harvest activities, you want to make sure that you keep that employment certificate within the personnel file. So along with your I-9s, and very similarly, they would need to fill out, their appropriate tax forms. You want to have that certificate as well. The certificate, if there's any question, is referred to as an AT-24, and then there's a AT-25 for employees who are 12 or 13-year-olds who might be working in those permitted areas. If you can, you might, to the extent you're uncertain or want clarity, you can certainly request a certificate of age as the documentation we were talking about demonstrating the individual's age, and that can be issued from a school authority if the individual doesn't have some other way of proving their age. You want to make sure you keep that permit where the individual is working. So I would say if you have different locations that individuals might be working, you might keep a couple copies, one in your main personnel file and one on the site where the minor employee is going to be working. And according to the regulation, the individual minor is supposed to keep the permit in their possession at all times. I've never had a case where I've had to be involved in that inquiry, but the regulation does specify that. Okay. In terms of hours of work, again, differences you'll see typically occur at 14 and 15 versus 16 or 17. Over 18, none of the states had any restrictions over 18, and then whether school is in session or not. So I won't read through all of them depending on, because I know we've got individuals from a variety of states, but you can see New York has very specific limitations in terms of how many hours per day, what's the total of hours in a week, and whether there's any limit on the number of days in a week that an individual can work. And again, there's also limitations for that group of 12 to 13-year-olds who are involved with hand harvesting of certain produce. All of the states also involve, or I should say most of the states have restrictions on night work. So you have restrictions about the total number of hours an individual could work in the day, and you generally have restrictions about the time of day that those individuals can work. And not surprisingly, they don't want children working too late at night when maybe they have homework or they should be getting some rest for school the next day. So again, New York sets out its rules, and they vary depending on generally between June 20th and Labor Day. They fluctuate a little bit there. New York has a provision about posting schedules. Again, I poked around, I couldn't find any cases that involved violation of this regulation. But I think it really ties into this idea that because children are not to be working out with, or may only work within certain parameters, that there's a requirement that their schedule be posted to ensure compliance. So I'm sure you make out a schedule to let the employees know, and you should post that and make sure, obviously, it complies with the rules if you're in New York. Okay, moving over to New Jersey. New Jersey also has a working paper requirement for children under 18. And again, this is not your responsibility to get as the employer. I know my own son recently got his working papers. Easy enough. I believe at his school he got them from the guidance counselor. Some folks get them from the principal's office, principal's assistant. But you just need to generally provide an offer letter on your letterhead indicating what the position is that you are offering that individual, so that then they can take that to their school and secure the working papers and those are what you need to keep in the personnel file. New Jersey specifically has a provision about minors being given a 30-minute meal period after 5 continuous hours of work. Other states have general meal period requirements for all employees. The times sometimes vary. For example, Connecticut happens to have a meal period requirement for all employees working more than 7.5 hours. Requires the employer to give a 30-minute meal period. New Jersey has this one specifically focused on minors. So you might keep that in mind in terms of when you schedule your workday. Okay. New Jersey, again, there's a good number of states that do allow employment of 12-year-olds, 12 and 13-year-olds within certain parameters. Again, what you really want to balance is a 12-year-old capable of following direction to keep themselves safe, depending on the activity and how much supervision you're going to be given. Sort of separate and apart from our specific conversation today of sort of work rules for minors, employers owe all of their employees, not just minors, but all employees, a safe working environment, and that's under OSHA. And if for whatever reason you're a farm not engaged in interstate commerce, that would subject you to OSHA. State laws typically require the same. So when you think about who you hire, you want to make sure that individual has at least demonstrated to your satisfaction the ability to engage in work safely and follow your direction. Because even if it's permitted, if you have reason to be concerned about that, you should not be hiring that individual. Okay. New Jersey, so in addition to the restrictions that we saw under federal law, the federal hazardous order, which identifies certain things in agriculture that employees, minor employees, may not be involved with. New Jersey also has a list of prohibited products that minor employees cannot work with. And I would suggest that I believe this was pretty unique to New Jersey, but I think it is actually pretty good reminder for other employers that, if you have minor employees, probably not to allow them near some of these products. Some of them obviously wouldn't be probably found on a farm, but many would. Pesticides in particular, different paint, depending on whether it has lead or not, and certain poisons, I could imagine, might be around the farm. So things to be careful about in terms of what a minor employee might come in contact with. Similarly, New Jersey has a list of prohibited machines that minor employees cannot work on. I did a quick review. It seems like many of these are also mentioned under the federal hazardous requirement. Basically, anything with moving parts that someone's fingers might get caught up in, certainly anything with a cutting capacity, those are items that minors shouldn't be involved with, and probably shouldn't even be working around in case there was, an accidental trip or something. You wouldn't want them getting caught up in that. Okay. New Jersey similarly has restricted work hours depending on whether school is in session or out of session, depending on age. Okay, I won't go through that, but if you're in New Jersey, you want to take note of that as you develop your work schedule. And then we begin to move over to New England. And it is interesting that New York and New Jersey had what I consider a larger body of their own restrictions. Moving over to New England, and I happen to be based in Connecticut and practice in Connecticut and Massachusetts, there seems to be less regulation, and I don't know if that's just something attributable to our history, where it was pretty commonplace for a lot of minors to be working. I know I had relatives, including my parents, both my parents working tobacco, and I've had other friends go up to Maine to work on potato farms. So, anyways, we're going to see less restrictions in these states, but we still see some of the common ones. So up in Maine, got to keep daily time records. You need that anyways. I'm assuming none of your minor employees are going to be salaried, so they're all going to be paid hourly. And just as with any hourly employee, you want to make sure you have accurate time records in case you're ever audited by either the state or federal DOL. But Maine has a specific requirement mentioning minors. Maine also requires parental permission. From what I can glean, that may be tied into their working papers, but the regulations simply mentioned parental permission. And for them, minors have to be given a 30-minute meal period after 6 hours of work. So we saw, I think it was New York after 5.5 or 5, and then here it's 6. Okay. Also, work restrictions, depending on whether school is in session or not, depending on the age. And most of the states had restrictions for not working more than 6 days in a row. So might keep that in mind when you're scheduling work to make sure your minor employees get at least a day off. A lot of states separately have the rules that you can't compel any employee to work more than 7 days in a row. But certainly folks can choose to work more than that. For Maine, they also have specific restrictions regarding work hours. And they also have restrictions regarding night work. This probably isn't a bigger deal in the agricultural world, but just be conscious of if there is any night activity to be sensitive to whether there's a regulation in your particular state. And again, Maine has some restrictions on restricted activities. I put up the ones that might pertain on a farm or in agriculture. And again, this would be in addition to what the federal hazardous orders provides. Maine had some pretty specific regulations dealing with driving. So generally, anyone under 17, any 16-year-olds should not be driving as part of work. Maine does allow individuals 17 or older to drive with certain restrictions. And so those restrictions are set out. Again, this is where you have to think about whether the 17-year-old has demonstrated, the maturity or a track record to give you confidence that they can operate a motor vehicle safely. Okay. And this ties into the motor vehicle restrictions. Moving a little south to Vermont. Vermont didn't have many restrictions, pretty much be following federal law, but did require the employment certificate and did require that employees be at least 14 years old. And if you're under 16, should only be working up to 8 hours a day, 40 hours a week, maximum 6 days in a week. New Hampshire has also did not have too many rules. Again, make sure you get your employment certificates. That's such an easy, I've had a couple employers in the states I've practiced with not have these, just like you want to make sure people has a properly filled out I-9 And a W-4, you want to make sure if anyone's under 18, you're at least asking the question about employment certificates. Okay. New Hampshire laid out what is the student's responsibility, and then what's the employer's responsibility. Again, having proof of age is important because you want to know at least what your understanding of that employee's age, so you know how to properly schedule them for work. New Hampshire has similar restrictions, and it is quite remarkable. A lot of these are very, if not similar, just off an hour or two, but there's certainly more commonality than differences between the states when it comes to these hour restrictions. And again, whether school is in or out of session is going to affect the time an employee can work for you who is a minor. Okay. Now down to Massachusetts. Again, Massachusetts has certain prohibited jobs, which would be in addition to what the federal law prohibits. Similar work restrictions in terms of hours and the amount of time someone can work who is a minor. Also, more hour restrictions depending on whether school is in session or not. Rhode Island had very few restrictions, generally following federal law, but did have 14 as its threshold and did require working papers. Connecticut, the last state in New England for us to talk about, very similar hour restrictions in terms of when school was in session or not. Required a statement of age issued by the superintendent, basically their working papers, and more hour restrictions. Connecticut doesn't have specific hour restrictions designated just to agriculture. They break it up into some different categories. I included the one for retail and manufacturing to give some sense of where I think the Department of Labor would probably be looking. And again, want to be thoughtful of when is school in session and not requiring too much of minor employees in terms of overtime. Okay, and again, Connecticut, like I think it was Maine or Vermont, restricts individuals from driving if they are of a certain age. Connecticut, you cannot have your employees who are 16 years old drive as part of their employment, and 17-year-olds may only do it for a limited part of their work time. Okay. Connecticut, again, has many jobs 14 and 15-year-olds can do, including agriculture. So again, as you go into the summer and you're thinking about hiring individuals, I think hiring minor employees is great. You could get, some employees who are very enthusiastic for having their first job. As an employer, you just need to be thinking in terms of scheduling those employees in a way that doesn't violate any of these activities, and making sure that no individuals engage in any activities that they are not permitted to. And basically, that involves active machinery. I'd also like to spend a little time today. I was asked to speak on internships. Now, internships fall into two general categories: paid and unpaid. If they're paid and you're going to pay minimum wage, all you need to do is be thinking about, those items that we have just walked through. The hour restrictions, the scheduling, and the activities. If you are not going to pay an individual as part of an internship program, there are certain things you need to be focused on. And the Department of Labor, I can tell you, has been sort of putting out some messaging that they are focusing on unpaid internships, and will be focusing on them again this summer. And the idea or the reason behind that is there are some employers who have taken an unfair advantage of interns and had them do a lot of work, provided little education, and not paid the individual. The safer course is if you can pay someone minimum wage as part of an internship program, then you don't even have to worry about some of the rules that I'm going to walk through with you in a moment. But if you decide you are not going to pay an individual, then you need to be thinking about these rules. And the federal government has, come out with a certain test. And I could tell you, certainly the states I practice in, Connecticut and Massachusetts, these general rules would also apply on a state level as well. The basic thrust from the Department of Labor's perspective is an internship program has to be designed for the benefit of the student. If you are not going to pay the individual, the primary benefit of the program has to be for the student to learn a certain skill that they were previously unequipped with. And in one commentary or in one fact sheet, the department went so far as to say that unpaid internships should be work for the employer if they do them properly, meaning it should be a bit of a burden on the employer in terms of providing that knowledge and teaching to the employee. But let's look specifically at the test, and we'll get a little more clarity as we go through it. Okay. So what I was just mentioning is the test sort of begins with who's the primary beneficiary of this arrangement. And again, we're only talking about unpaid internships. If the primary beneficiary is the employer, meaning the employer is getting free services, they're probably going to fail the test, and they should have paid the individual. If the primary beneficiary of the internship program is the student, then you may be fine not paying the individual. And what they really do is look through a series of factors, 7 factors in particular, to sort of discern who is the primary beneficiary. So the first one, the extent to which the intern and the employer have a clear understanding that there's no compensation. It's always the case that an employer and an employee should have a clear understanding of what they are going to be paid. No one should be in doubt in terms of what they will receive from their employer, and at the same token, there should be no doubt what the employer is obligated to pay. So when you write your offer letters, you want to be clear, and that's why most offer letters include the terms of compensation. Is the position a non-exempt one or an exempt one? What's the rate of pay? Similarly, when you are dealing with an intern, if you're not going to be paying that intern, you want to make it clear what is the terms of the relationship. And if you're not going to pay them, I would recommend that you make that perfectly clear in an offer letter for that internship. Okay. If there is any promise, either express or implied, that there may be some compensation, then they're going to be considered an employee. And if they're an employee, you need to make sure they are meeting minimum wage requirements. So that's why having clarity is very important on the front end. The second factor, the extent to which the internship program provides training such that it's comparable to training they might receive in an educational environment. So, what sort of things are you going to do to provide instruction to the student intern so that they are actually learning as part of their experience in the internship? There's a lot of stories, some of which involve the movie industry where interns are just basically tasked with, fetching things and doing very menial tasks. That kind of intern must be paid. They are not deriving a lot of education. And this is one of the factors that the department will point to and say this is where the employer has to take on the responsibility of providing some education to the intern if they are not going to pay them. So when you think about what's that internship look like, what opportunities will the student have to do some hands-on experimental or experiential kind of learning? If you're not going to pay someone, you want to be able to certainly point to some aspects of the program that provide that benefit. Third, to what extent is the internship tied to the program that the intern is pursuing? I would imagine this factor is not going to be probably too difficult, especially if someone is studying some form of agriculture, at school, or veterinarian science, or something of that like. But, if you had someone who was, studying to be a dentist, show up to do an internship on a farm, you may not pass this factor. So really, when you think about who you're bringing on as an intern and not paying them, you want to really focus on, well, how is this going to tie into their larger plan? Sometimes it ties explicitly through coursework and credit that they might get from their college or university. But it's certainly a conversation you'll want to have before you have someone provide service without being paid. Fourth, the extent to which the internship accommodates the intern's commitments. Now, this may not be as big of a factor in the summer as an internship maybe in the fall. But again, recognizing that the internship is supposed to support and promote education for the intern, you want to make sure that the internship is not conflicting with the intern's academic requirements. Factor 5 is the extent to which the internship's duration is limited for a period of time, usually a semester or maybe the summer. If it goes on for an extended period of time, it's really going to look more like an employment relationship and one for which the employee should be paid. 6 is a practical factor. What type of work is the intern doing? And is the intern really taking the place of an employee? If that is true, the intern probably should be paid. The intern should not be displacing an employee, because if that's the case, the intern is probably benefiting the employer. And again, going to, the sort of overall takeaway is, if you're not going to pay an intern, they have to be the primary beneficiary of the relationship, not the employer. And 7 really ties back to the first factor about being clear, and that's the extent to which the intern and the employer understand the internship is conducted without entitlement to a paid job at the end. Again, it's considering the clarity of what it is. And the reason for factor number 7 is you don't get to treat an internship program as a probationary period. So you don't get to say, if you, and again, this is just for unpaid internships, work for me for the summer, and if I like the kind of work you do, we may offer you a job at the end of the summer. That looks more like a probation for which an individual should be paid. Again, when you take all these factors together, the real point is if you're not going to pay someone, you want to be able to say their participation in the internship program benefited them more than it benefited the employer. If that's the case, then you can have an unpaid internship. And with that, I am done for the formal presentation, but I would welcome any questions or comments that you might have.
Okay, so Mike, we did get quite a few questions.
Right.
So I think the first one is given the relatively small geographic location that the Northeast and New England is, we may have farms that are a student lives in, say, Massachusetts, but they work right across the line in Connecticut. Is there any additional guidelines they need to follow, and which guidelines do they need to follow?
Generally speaking, when it comes to these work restrictions, it's work where the work is performed. So if and I grew up in Summers, as I mentioned, and some of my jobs, I was a mile away from the Massachusetts border, is where you work. There's other types of employment law where you live might be a factor, in particularly taxes. But generally speaking, the rules we've been talking about, it's where the work's performed. If for whatever reason you have a farm that straddles two states, then I would try to comply with all of the rules, meaning look at both states' set of rules and comply with the most conservative.
Okay. I think you covered this, but if you employ your own child on the farm, is there an age restriction, and what is that age
Nope.
that they can start?
Yeah, no. As far as I can tell in reviewing these statutes, they all recognize that if it's your child, you could have your child working at any age on the farm. It's really seen more as a parental responsibility. There were a couple rules, and you'll see in here that extend, like if you're going to your uncle's farm, you might have some indulgences or more latitude, but you have the fullest latitude if it's your own son or daughter. If you are bringing, your grandchild on the farm, or a cousin or a niece or nephew, your ability to not comply with the rules, I think, changes a little bit, and you'd want to be clear about the relationship to that individual. But if it's your son or daughter, you have full freedom.
Okay. On kind of duties that a teen would be employing or doing, we had someone ask, say they went to the school, they submitted the paperwork, and the paperwork says they're going to be doing register, walking people, folding boxes, things like that. Nothing of that kind of hazardous classification, but they
Yeah.
got pushback from the school saying that they're only allowed to like bag, stock, kind of cashier. Any wiggle room on that, or how would the best way to proceed on that?
Yeah. One is I'm surprised at the pushback. The only thing I'm thinking of with like folding boxes, if it involves working with a sharp edge, to deal with
Mhm.
the tape to fold the box, maybe that would be of concern. And that again gets to whether, those kind of tools should be used by minors. But I'm not sure what the pushback is. I think if I was truly uncertain about it, I might call the school and just inquire, and it might be a matter of just a misinterpretation of how it's
Mhm.
written. That'd probably be, the way I would handle that.
Okay. Um, so I know when I was growing up, being a 14, 15-year-old, I did kind of the tractor safety program when I was 14, 15 to work on farms as an additional certificate. Did you find any of that same thing here in the Northeast as kind of a requirement or needed paperwork for working on a farm at 14, 15 years old?
Yeah, so 14, 15, I'm not sure I saw anything that would allow operating a tractor at that age. 16, 17, some of the states I think allow it, some do not. And again, I'm taking out family members. So,
Mhm.
a child who grows up on a farm probably is driving a tractor at a very young age, and has learned to do that. But I can think of some of the states we just reviewed. They have explicit restrictions on operating motor vehicles, including tractors. I think it was Maine or Vermont had very specific rules, and Connecticut had a rule that if you were 17, only 25% of your job duty could be operating a motor vehicle, and tractors normally fall within that category.
Okay. So a lot of our farms are structured different ways, from corporations to single party LLCs or multi-partner LLCs or general partnerships. Is the Does the structure of the farm matter when it comes to children, and the teen employment?
Yeah, I would say generally not. So, generally, in any employment situation, the employer is going to be the responsible entity, right? So,
Mhm.
what is that entity that's issuing a paycheck? The caveat I'll add is if there's certain circumstances, and a wage and hour violation is a good example of this, where employer can include individuals. So, in this particular area, I didn't come across it, but it would not be surprising if there was an individual intimately knowledgeable about someone's minor status and deliberately disregarded the rules. There could be individual liability. But generally speaking, liability begins and ends with the employer, however that employer is created.
Okay, and that would go for the business owner's children.
Yeah, well, again, the
Yeah.
children, generally, it's more of a parental issue.
Okay.
Your chores will be, in my house, my son,
Mhm.
one of my son's chores is to mow the grass. On a farm, it may be, go bring up the cows from the field. So
Mhm.
it's more of a parental issue rather than an employment issue.
Okay. Um, we did have, I think, this is more on the volunteer side of things. Can a student gain volunteer hours working on a farm, or would this be up to the school to decide?
So, if I didn't specifically look at this, but in the past I've had occasion to look at it. It depends if the farm is a for-profit farm or not. If it's for-profit, you generally can't have volunteers. If, like in our area, we have a farm that straddles Bloomfield and Simsbury, Connecticut, I believe. That's more of a 4-H farm, not for profit, and yes, people do volunteer there. But if you're a for profit, um, then if you were going to have, quote, a volunteer, I'd want to look at, can I comply with the basically unpaid internship rules. Um, and if I couldn't do that, I would pay the individual minimum wage.
Okay. So we are coming up at the top of the hour here. So, Mike, is there any final thoughts, comments, areas of direction where people should go as they have more questions, or resources that you are aware of, if they have more, if they kind of want to look into this, or they have teens coming up, um, employment status that they can access?
Yeah, I can tell you that the state departments of labor are usually a really good resource. Federal Department of Labor, I think, can be bureaucratic in getting answers, but I can speak to Connecticut and Massachusetts where I've had to just run a quick question by, and I find those departments very helpful. And when you call, you don't have to give your name if you're not comfortable doing that. But what I would do is have all the facts pertinent. So if you have a certain job description that you want to get clarity on, make sure you share those facts so that whoever answers your question has all the details they need to give you the correct answer.
Okay. Well, again, Mike, I appreciate all this wonderful information that you've been able to provide to the Northeast as it relates to teen employment. And as a reminder to everybody else, the webinar has been recorded, and the materials will also be posted to farmcrediteast.com /webinars, as you see on your screen, as well as our YouTube channel. If you just search Farm Credit East, we're usually one of the first ones to pop up, as well as all past, present, and future webinars will be on there as well on our website and our YouTube channel. Again, Mike, thanks for this great opportunity. And with that, we will close out for the rest of this beautiful New England day.
Terrific. Thanks. Have a good summer, everyone. Bye.